Got the chest cold, so
Oh no.
doing a lot of coughing.
Okay. We do have cough drops if you need any down here.
Mr. Blumberg, what case are you signing in on today?
The Crucell case. I just got retained over the weekend. We're
Okay,
filing our
sounds
appearance this morning.
Second.
You're welcome.
All right, looks like we have everybody connected, so we'll go on the record in Purcell versus Purcell. This is file number 2419939, and if I could just have both counsel put your appearances on for the record today.
Good morning, Your Honor. Brooke Robinson appearing on behalf of the plaintiff, Kendall Kressel.
Good morning again, Judge Elliott Blumberg. I've just been retained representing Melissa Crucell, the defendant.
Okay, this was set for a status conference today. Mr. Blumberg, recognizing that you've just recently been retained on this. Ms. Robinson, I'll just start with you. Like, can you, from your standpoint at least, can you tell me where things are at? What you'd like to request for scheduling going forward?
Yes, Your Honor. Thank you. The plaintiff and the defendant came having a general understanding of child custody and property settlement in mind when we started this. We have put together a judgment of divorce, and then I think a couple property issues came up. And then I was recently informed that Mr. Blumberg was retained, so I understand that we may have some open issues. We don't know exactly what those open issues are, but I do have the hope that we can settle this within a reasonable time frame, obviously deferring to the defendant and what they have as far as their expectations of this.
Okay, Mr. Blumberg?
Judge, again, I have reviewed some documents which suggest to me that there was some type of post-nuptial agreement that was signed by the parties, prepared by the plaintiff prior to the filing of the divorce action. Whether or not that document or documents actually meet the requisite requirements of a post-nuptial agreement. That is, I don't believe there was ever a disclosure of assets, any type of discovery or at least a revealing of assets prior to the signing of that. So I'm not at this point prepared to agree that all of those issues are resolved. I'd like to be able to review them, perhaps find out what the circumstances were that caused the plaintiff to prepare the documents. There is a custody agreement that you've signed as a result of agreement was placed on the record before the referee. That custody and parenting time arrangement doesn't seem to make a lot of sense given where the parties live and the distance between the two households. So I think we need a little bit of time to explore whether or not the property agreement is in fact enforceable and is whether or not it's reasonable. If the court could extend another 30 days for us to review those documents and perhaps reschedule another status conference, we'll be in a much better position to determine where we're at.
Okay, Ms. Robinson, do you have any objection to that?
I do not, Your Honor.
Okay, so that's what we'll do. That'll give both counsel a chance to, it'll give Mr. Blumberg a chance to review all the documents, give counsel a chance to review, consult with each other to see if we can reach an agreement. So we'll set this for another hearing in 30 days. If you've both been able to resolve those issues, then we can take proofs at that time, and if not, it sounds like we'll be in a better position to schedule going further. Ms. Robinson, anything further I can address for your side today?
No, Your Honor. Thank you very much.
Mr. Blumberg?
No, Judge, thank you. Appreciate you allowing me to show up today.
Okay, thank you. And all parties on this file are free to disconnect at this time.
Thank you.
Thanks.
All right, Mr. Morrison, are you able to hear me okay?
Yes, Your Honor.
Thank you. Go on the record in Morrison versus Morrison. This is file number 2319363. Record should reflect that Mr. Morrison is present today by video. Let's see, Miss Morrison connected. Miss Kraus or Miss Spillane, if you can, both of you, one of you can hear me, if one of you can sign in here on this file. Miss Spillane, great, thank you. Are you the caseworker on this file?
Yes, sir, I am.
Okay, I was just looking through the file. It looks like there was a hearing back in May where Mr. Morrison was to have a substance use assessment. It looks like that occurred. Can you tell me what the status is of the proceedings there with front of the court?
Yep, he does have that, and then we have a hearing again with the referee. Next month on August 13th.
Okay. All right. So I think, Mr. Morrison, what my plan would be to have you guys have that hearing, see if there's any objections that come out of that, and then if there aren't, then schedule this for a final hearing so that we can finalize the divorce. Do you have any objection to that?
No, I don't. I do have a couple questions as to pertaining to the mediation that was attempted to take place. We scheduled it. We had what we wanted. Well, she had what she wanted for it, and it just didn't go through. She failed to provide the documents pertaining to the alleged debt that we accumulated together. And
Okay.
it's just I kind of want to get things rolling, and I'm kind of tired of being the one to pick up all the slack, and I just kind of want the court to recognize that.
So you guys attended mediation back in June, right?
Yes, sir.
Okay, and you're saying that she was supposed to bring some documents to that and she did not do that?
Correct. That was why the mediation couldn't go forward, is because she claimed we had debt together and then couldn't provide the documents.
Okay, so certainly, yeah, in terms of whether or not or how the court should divide that up, one of the requirements is that you're both to meaningfully participate in the mediation process. If she did not do that, then that's something that's a factor that would work in your favor. Also, I mean, I would note that she's not appearing for the hearing here today.
And that I also mentioned, this is the third hearing she hasn't appeared for.
Yeah. So, at some point, she loses the ability to argue things like that when she's not appearing for hearings. But that's something that, that's an argument that you will need to make when we get to that point about how to divide up the assets or debts. But your statements are here on the record today. I recognize that she's not present, so that's something that I can take note of, and then I may have to take testimony from you at some point regarding what happened at mediation.
Okay.
But those are all factors to answer your question that the court would take into account in terms of how to divide up the debts.
Okay. Thank you, Your Honor. I appreciate that.
Okay. All right. Thank you. So the court will set this for a hearing in September to finalize the divorce, hopefully at that point, and all parties are free to disconnect at this time. Thank you.
Thank you, Your Honor. Have a great day.
All right, we'll go on the record in McGovern versus Zadney. This is file number 2419592. This hearing was set for 9:15 today. It's now 9:21. Neither party has appeared on this file. It looks like everything should be settled and the court is just waiting for the parties to provide a final order for signing. Ms. Spillane, do you have any further information on this file?
I do not. I have tried to reach out to the parties and I have not had any success in having contact with anyone to remind them to bring that in.
Okay. All right. So I'm going to set this for one final hearing in 30 days. If neither party appears for that, then the court will determine how to proceed at that point. So we'll give them one more opportunity. So that's it for that file. Thank you. And our next hearing's at 9:30, so we'll take a short recess until that time. All right, good morning, whoever's joining us on the phone with the last four digits of 2814. Can you tell me your name, please?
Ty Gatewood Cotton.
Okay, thank you. Okay, if I can have both counsel unmute, please. We'll go on the record in Cotton versus Cotton. This is file number 2319201. If I can have both counsel put your appearances on, starting with plaintiff.
Morning, Your Honor. Jennifer Dusman-Coy on behalf of Taylor Cotton, who is present with me in my office.
Good morning, Your Honor. Katie Komorowski on behalf of the defendant, Ty Cotton, who is present on Zoom via telephone.
Okay, thank you. This is set for a status conference today, as well as Ms. Komorowski, your side has filed an objection to the referee's recommendation with regard to child support. I did have a chance to review your objection and your response, Ms. Dukes-McCoy. And so to me, it looks like there's two issues. Number one, that Ms. Komorowski that you raised, number one, whether and to what extent Mr. Cotton's disability income should be used for purposes of child support in the calculation, and whether or not there should be a deviation for that and other reasons from the standard formula. Is that a fair kind of summary, I guess?
Yes, Your Honor.
Okay. And Ms. Dukes-McCoy, it sounds like your position is that Mr. Cotton's disability payments aren't part of the property settlement in terms of division of assets and debts of the marriage. That pursuant to the mediation agreement, he gets to keep that, but that doesn't mean that it's not income that could be used for purposes of determining the amount of child support. Is that kind of your position?
Yes, it is, Your Honor.
Okay, and then you're opposing any kind of deviation, is that also correct?
Yes, Your Honor.
Okay, so, I mean, in my view, the issue about whether or not the disability payments are part of a separate property settlement agreement as part of the division of the assets and debts of the marriage, and whether or not that can't be touched for purposes of child support or considered as income for purposes of child support. To me, that's a legal issue. Whether or not there should be a deviation, regardless of the decision on that, to me is more of a factual issue. So I think we would need to set this for an evidentiary hearing. I would anticipate, even though counsel's kind of laid that out, both of you in your objection and response, having arguments as to the legal issue and then taking testimony as to whether or not there should be a deviation. So I guess it would be my intention to set that for maybe a half a day hearing so that we can address all of those issues. Ms. Komorowski, do you have any objection to that?
I don't object to that, Your Honor. I would just like to state for the record that in the mediation agreement, my client made that agreement with the understanding that there were certain things that he was giving up as part of that agreement, as I laid out in the motion. So by him keeping all of the VA disability pay and it not being included in the child support calculation, he gave his wife half of his TSP 401k without any argument with court, which effectively amounts to about 15% additional amount for her, as I laid out in that motion. And so I would just say that my client's position is that if the court finds that that's not what we agreed to, even though that's what Mr. Cotton's intent was at the time of making that contract, that we would be asking in the future, and as I put in this motion, and the alternative to set that agreement aside and have you make a determination on those things that we had agreed to before.
Okay, yeah, and I mean, I think that what you just said highlights the fact that we kind of have mixed issues of fact and law here with which would require an evidentiary hearing. Ms. Dutzman-Coy, do you have any objection to that procedure for resolving this?
Not to the procedure, Your Honor. Obviously, I disagree with the statements that were made and I think we stated that in our response to the objection. I don't feel that this merits an evidentiary hearing because I think what we're talking about is what the defendant thought he was getting into. And frankly, we mediated this 2 years ago. And the court can't look at what the defendant thought at the time. The court can't look at whether this is fair to him. We already went over all of this in October of 2023. And so this is something that I think has already been argued by counsel. And I'm a little frustrated, Your Honor, because these parties are at the point where a judgment of divorce can be entered. I feel that this objection is meritless, and now to have an evidentiary hearing on it, it just feels like these parties are never going to get divorced. And so it's frustrating to me that now we have another delay when I feel that this is a meritless objection.
Okay, and I mean, I get your position with regard to the mediation agreement, but doesn't Mr. Cotton still have the right to object to the child support recommendation on the basis that he's entitled to some kind of deviation? I mean,
I would agree with that, Your Honor, if any deviation factor was laid out in the objection, but there was no deviation factor. All that Mr. Cotton has said, in essence, is that this is unfair to me. I don't want my VA disability pay to be considered. That's it. And so I don't know what the basis of the deviation is, other than he feels that the agreement was unfair to him.
well, what I'm getting is that, you know, part of a court's consideration in whether or not to grant a deviation is what parties have received in terms of other property of the marriage. Like, I mean, the court can take that into consideration as part of a request for a deviation. So I guess, I mean, we can hash this out during the hearing. And I'm just addressing your point of being frustrated with the objection. Again, I guess my point is that even if the objection is found to be meritless, I think there's still a valid argument to be made with regard to a deviation. So I don't view the process of requiring another hearing here to be something that's outside the scope of what the defendant is entitled to challenge as part of the child support consideration. So I'm just making a record of that. But is a half a day enough time, Ms. Dutzman-Coy, if we do need to take some testimony as to a deviation? Do you believe that that would be enough time?
I think that would be enough time, Your Honor.
Ms. Komaraski, do you think that's enough time?
Yes, Your Honor.
So I'm aware that this case it's taken a while. And so I'm going to schedule it for the soonest possible date. And the court will be prepared to rule on it at the time of that hearing so that we can keep things moving and hopefully get to a resolution. I know the parties want that, and certainly on behalf of the court, I'd like to get this resolved as well. So the court will send out a notice of the date and time of that hearing. Ms. Dutzman-Coy, is there anything else that I can address for your side today?
Not today, Your Honor, but I just wanted to, I guess, emphasize for this record that we are going to ask vehemently for attorney fees because we feel that this is frankly a waste of time and these parties need to get divorced. But I understand that the court wants to proceed on the evidentiary hearing, and I think at the evidentiary hearing, we will again request attorney fees and sanctions because this is a meritless objection. But I just wanted to state that for the record, Your Honor. Thank you.
All right. And I just want to make clear, it's not that I want to have another evidentiary hearing in this case. I think the defendant's entitled to it under the law. And so I think we need to do that in order for the court to make a decision. So Ms. Komaraski, is there anything else that I can address for your side?
Nothing further, Your Honor. Thank you.
All right. Okay, thank you. That's all for this hearing today. All parties on this file are free to disconnect at this time.
Thank you, Your Honor.
Okay, we'll go on the record in file number 2419704, Peters versus Peters. This matter was set for hearing at 10 a.m. It's now 10:06. Neither party has appeared for the hearing today. We've been waiting on confirmation. One or more of the parties needed to complete the SMILE program. Ms. Spillane, did you have any additional information for the court on this file?
No, sir. I did check this morning to see if by chance either of them have registered for our class tonight, and neither of them have.
Okay, so the court, I believe, had a hearing with Ms. Peters last month. Where I again made it clear that we couldn't proceed until both of them completed this program. Mr. Peters, I believe, did not appear for that hearing last month. Either way, both parties have been given multiple chances to do this. They've both been made fully aware of what they needed to do. It's an online program. I'm trying to see how many times the court has adjourned this matter for them to do this. It's been numerous, and going back at least until it looks like March. So, and I believe I informed Ms. Peters last time on the record that the court would dismiss this case today if they had not complied, and they haven't. So I do have a dismissal prepared. The court will sign that today, and the parties want to proceed with their divorce, they'll have to refile. Ms. Spillane, anything that you needed to add for the record on this today?
No, sir.
All right, thank you. That's all on this file. Our next hearing is at 10:15. Okay, we have all the parties connected. We'll go on the record in file number 2520095. If I could have both counsel put your appearances on, starting with plaintiff, please.
Thank you, Your Honor. Good morning again. Jennifer McCoy on behalf of Adrena Rudy, who's present with me in my office.
Good morning, Your Honor. Jody Doak, appearing on behalf of Nick Rudy, who is here with me.
Okay, we're on the record here today. Back in May, the court entered a mutual restraining order regarding the preservation and the assets of the marriage, as well as joining certain conduct by both parties in terms of disposing of those assets. Ms. Doak, you filed an objection to that order. I did have a chance to review your objection and your proposed changes to that order. Ms. Dukes-McCoy, I did receive your response as well. Ms. Doak, is there anything that you wanted to state today for the record in support of your objection?
Yes, Your Honor. Just to give the court a little bit more perspective of my client does bathrooms, like remodels bathrooms for a living. And so he's literally in and out of Home Depot, Menards, all these places multiple times a day. He's paying subcontractors. He's had a look at his tax return. You know, he would have like $400,000 about go through the a corporation, and $360,000 in material men and materials and stuff like that. So with the way that works, him stopping constantly to notify the other party that he's paying a debt or an obligation would just be overwhelming, and it would be unduly burdensome to him. And it's not anything that these parties have ever done. He's been living in Boyne City for 11 months at this point. He moved out about mid-August of 2024. And he and so there's not been any demand for any of this kind of information. Then it was presented to the court in the form of an ex parte emergency motion saying they needed this information to be provided, you know, pretty much daily as a part of an emergency, when it was never even requested. Status quo literally means the existing state of affairs. And in the order that was signed by the court, there is a part of the order is that the party would pay the bills that they've paid historically, which usually in a status quo order, it would be that the court would enforce the existing state of affairs, which the other party listed out the bills that the wife was paying right now and the bills that my client were paying accurately. So if the existing state of affairs is enforced, that should continue until there's a motion by either party with appropriate notice to change that, or for spousal support, or for whatever the other party decides to motion for. So since the court's reviewed my motion, I'm not going to go further into this. I trust that the court has reviewed that, and I know you do. So thank you. That's what I wanted to say.
All right, thank you. Ms. Dukes-McCoy?
Thank you, Your Honor. I don't feel that, as we stated in our response to the objection to the order, I don't feel that the order requires this burden of the defendant having to contact the plaintiff every single time he goes out to purchase something. I don't think that's the spirit of the order, and I don't think it even says that in the order. So I don't feel that at present, the way that the order is drafted, I don't feel that it's unduly burdensome upon the defendant. And my concern is, as I stated, is that if we change some of the language in this order, that the defendant, under the guise of acting under the business, is going to be making all these large purchases, saying, oh, that's a business expense, that's a business expense. To my understanding, he's purchased a brand new truck since the parties have been separated. And I'm not sure exactly when that occurred, but it's a 2025 vehicle allegedly for his business. But so my concern is that if we say, nope, he doesn't have to report any of these things, that we're going to find out that he committed these large expenses, again, under the guise of the business, and I'll find that out in discovery after it's too late.
Okay. All right, I guess, I mean, Ms. Dutzman-Coy, in terms of, you know, daily expenses of the business, is that something that you're contemplating that this order would cover? Like if he is buying materials for jobs and so forth?
I don't expect this order to be something that would require the defendant to report to the plaintiff, you know, I went out to Home Depot and bought $3,000 worth of material, or I paid a subcontractor $5,000 for doing this work for me. I don't expect that from this order, no, Your Honor.
Okay, I mean, I'm just looking at paragraph number 9 of the order, which indicates using income streams to reinvest into business or other ventures, which, you know, I think is a fair part of the order. That's something that neither party should be doing. I think the more problematic language is to pay debt or any obligations of any kind without disclosing the same to the other party. And, you know, I mean, that's a pretty broad statement that could be read to require Mr. Rowdy to report everything that he spends money on to the plaintiffs. Otherwise, he's at risk of being in violation of the order because the language is so broad. So, I mean, do you have an objection to adding, you know, other than in the ordinary course of business, to paragraph number 9 to the end of that?
No, I have no objection.
Okay. All right. So, Ms. Doak, the court is going to grant your objection to the extent that that language should be added to paragraph number 9. And that language is except in the ordinary course of business. The court is going to deny the objection regarding the remainder of the ex parte order. However, I do think what needs to happen, because it does sound like, you know, Ms. Rowdy's is working, is earning an income, which is different than from what happened during the marriage. Based on the pleadings, it sounds like Ms. Rowdy did not work during the marriage. And so I think in terms of the payment of bills and everything, the court's going to leave the order in place as of right now. But Ms. Dutzman-Coy, I did note in the file that you did file a motion for temporary spousal support along with the complaint for divorce. So I think what we really need to do is have a hearing on that temporary spousal support issue, where the court can take some testimony, get some evidence as to the actual incomes of the parties, and then issue an order regarding support. And then Ms. Doak, I would anticipate, you know, as part of that, then that would allow the incomes to be equalized during at least the pendency of the divorce. And then that would give the court a better idea of where each side's at in terms of their ability to pay bills. And then I would suspect that this restraining order, to the extent that it requires Mr. Rowdy to continue paying bills and so forth, would be modified once the court has a better understanding of the incomes of the parties and the abilities of each to pay those kind of things. So to the extent that you're asking the court to change the order or modify it in terms of Mr. Rowdy's requirement to pay, you know, the mortgage and bills, I don't think I'm in a position to either grant or deny that at this point. Again, I think we need to have a hearing, and the court needs to take some testimony regarding incomes and obligations of the parties. So Ms. Dutzman-Coy, what I would request is that you notice that motion for temporary spousal support for a hearing, and then we go forward from there.
Yes, Your Honor.
Your Honor, would you be then anticipating that the language that says the party should pay the bills they've historically paid would mean that they should be paying what they've been paying for the last 11 months?
I mean, I don't know what, again, I don't have any evidence as to what has historically been paid. I don't have any evidence as to what the bills actually are. I don't have any evidence as to what the incomes are currently of each of the parties. So however they've been operating, since late summer of 2024. And however they've been operating in particular since this order was entered in May needs to continue until we can have that hearing.
Okay. And then my other question, just for clarity with the court, this number 11 indicates that preventing the other party from having the use of a vehicle regardless of the status of title, or preventing the other party from having the use of other personal property, including but not limited to electronic devices, cellular telephones, pets, banks accounts, or streams of income. I'm assuming that the intent is not that the parties can walk up to each other and say, hand me your cell phone, hand over your private, your separate bank account so that I can have use of the money in it, unless it's a joint account, that it's meant to just prevent them from not having use of their own personal devices, etc.
Right. I mean, I read that as, you know, neither party can, if, you know, depending on how things are titled, you know, in other words, if there's a vehicle that Miss Rowdy's using, even though it's titled in Mr. Rowdy's name, he can't go and take that vehicle and prevent her from using it. If she's been, you know, that's been considered to be her vehicle for her use during marriage, I guess is the way I would read that. But yeah, I don't read that as either side having access to the other side's personal property. It's just preventing one side or the other from stopping the other party from using what they've traditionally used as their own.
Okay. Thank you for that clarity, Your Honor.
Ms. Dukes-McCoy, is that a fair assessment?
I would agree with that, Your Honor. Thank you.
Okay. Okay, so Ms. Dukes-McCoy, I'm going to ask that you contact my office and get a hearing date for that motion within the next 7 days.
Yes, Your Honor.
Not a hearing within the next 7 days, but a date within the next 7 days.
I understand.
Okay.
Is the
Right.
court going to just write that into the order then, or does another order need to be submitted?
I can write that into the original right now. Ms. Dukes-McCoy, do you have any objection to the court doing that?
I do not, Your Honor. Thank you.
Okay, so I'll write that in right now. That'll save both sides some time and expense.
Appreciate that, Your Honor.
Okay, and I'll note that I'm adding it and with the date that I'm adding it in there as well. And then if either side wants a copy of that for your records, just contact the clerk's office.
Yes, Your Honor.
Yes, sir.
Okay, and then Ms. Dukes-McCoy and Ms. Doak, the court will set for status conference at the same time and date as the motion for temporary support once that's set.
Thank you.
Okay, thank you. That's all I have for today. All parties are free to disconnect on the spot.
Thank you, Your Honor.
Thank you.
Ma'am, can you unmute, please? Can you tell me your name?
Katie Sheridan.
Okay, thank you.
It's Kathy, my legal name.
Okay. Okay, we'll go on the record in Sheridan versus Sheridan. This is file number 2419880. If I could have both parties put your appearances on, starting with plaintiff, please.
Good morning, Your Honor. Brooke Robinson appearing on behalf of the plaintiff, Douglas Sheridan, who is seated to my right and appearing via Zoom in my conference room.
Good morning again, Judge Elliott Blumberg on behalf of Kathy Sheridan, who is appearing for Zoom from some unknown location.
Okay, thank you. We're on the record today for a status conference, and excuse me, it looks like the parties did participate in mediation as required by the court. That did not result in settlement. Ms. Robinson, can you tell me where things are at as of today?
Yes, Your Honor. We are very close to an agreement. Judgment of divorce has been drawn up based off of an agreement made between Mr. Sheridan and Ms. Sheridan. And I believe I received an email from opposing counsel this weekend who said he had a few revisions. We should have a time to chat about those revisions, but I believe we should be able to set this for our pro-con.
Okay, Mr. Blumberg?
Judge, yes, that's correct. I did receive a proposed judgment. There are some revisions that need to be made, but I would not be opposed because I think there is a basis for a general agreement to preserve the proofs. And if counsel wanted to take those proofs from her client, we would have no objection to that.
Yeah, I mean, that would prevent an additional hearing. Ms. Robinson, are you prepared to do that today? Do you have any objection to that?
I do not have any objection to that, Your Honor.
Okay, so I'm going to place both parties under oath. So Mr. and Ms. Sheridan, if you could both raise your right hands, please. Do you both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do.
Thank you. You can lower your hands. And Ms. Robinson, if you wanted to proceed as to your client, please.
Yes, Your Honor. Mr. Sheridan, please state your full name for the record.
Douglas Patrick Sheridan,
What is your current address?
9680 Turtle Lake Road, Johannesburg, Michigan.
Have you been a resident of the state of Michigan for at least 180 days and of Otsego County for at least 10 days immediately preceding the filing of this case?
Yes, I have.
Are you currently married to the defendant?
Yes, I am.
When and where were you married?
In Mansalona, Michigan, on August 23rd, 2014. Or 15. One of the two.
14.
14, okay.
Has there been a breakdown in the marital relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood that the marriage can be preserved?
Yes.
Are there any minor children born of this marriage, born prior to the marriage or adopted during the marriage?
No, there isn't.
Is the defendant currently pregnant?
No, she's not that I know of. No, she's not.
Have you entered into, or have you developed a written agreement with defendant regarding all issues in this case, including division of property and debts and waiver of spousal support, or excuse me, including division of property and debts?
Yes, I have.
Okay. Is that written agreement incorporated to a judgment of divorce that will be presented to the court?
Yes.
Have you had an opportunity to review the judgment?
Yes, I have.
As to the material provisions regarding property settlement, is it accurate and do you believe it resolves all outstanding issues fairly and equitably?
Yes, I have. Yes, I do.
Will you be asking the court to enter a judgment of divorce as your final judgment?
Yes.
Your Honor, are the proofs sufficient for today?
Yes, Mr. Blumberg, did you have any additional questions for Mr. Sheridan?
Only that, again, the details of the property settlement are incorporated. I don't know that we have to go through all of those right now, but there is a provision, is there not, sir, for the payment of spousal support in this case?
or something, but
Yes, there is.
Okay, and again, we don't need to put all of those things on the record. I believe that they're accurate, but again, there's some issues relating to some of the language in the complaint. Other than that, do you believe that the division of both assets and debts is both fair and equitable?
Yes, I do.
Okay, I have no other questions of Mr. Sheridan.
Did you want to take any testimony from your client?
I do briefly, if we could.
Okay, yes, please proceed.
Kathy, you understand that it has been represented to me that both you and Mr. Sheridan have come to an agreement as to the division of the marital estate. Is that correct?
Yes, it is.
And if that's been reduced to writing in some fashion, have you had the opportunity to review that?
Yes, I have.
Okay, and again, without going into all the details, do you believe that that agreement is both fair and equitable?
Yes, I do.
Okay, and I think we need to at least confirm for the record that you're not currently pregnant. Is that correct?
Absolutely correct.
Okay.
Thank you.
And again, just so that the record is clear, there is a provision within this consent judgment that provides spousal support for you. Is that your understanding as well?
That is.
And
Correct.
you've agreed to both the amount and the duration of that support. Is that correct?
Yes, I have.
Okay, thank you. Judge, I have no other questions.
Ms. Robinson, did you have any questions for Ms. Sheridan?
No, Your Honor, I do not.
Okay. All right, the court finds that the statutory grounds for divorce have been met by the testimony of both parties. The court will grant the divorce, however, as counsel is aware, it won't be final until that judgment is prepared and submitted to the court for signing. So, Mr. and Ms. Sheridan, just make sure that you can cooperate with your attorneys so that we can get that prepared and to me for signature, because your divorce won't be final until I sign that judgment.
Yes, Your Honor.
Yes, Your Honor.
Ms. Robinson, anything further from your standpoint today?
No, Your Honor, thank you.
Mr. Blumberg?
No, Judge, I'm satisfied. Thanks.
Okay, thank you. That's all for this hearing, and all parties are free to disconnect.
Thank you.
Thank you.
You.
All right, good morning. Whoever's on the phone with the last four digits, 2450, can you tell me your name?
Christopher Miller.
Mr. Miller, okay. If you can just hold on 1 second, I'm connecting Miss Miller right now.
Okay.
Miss Miller, if you're there, Miss Miller, can you hear me? Miss Miller, are you able to hear me okay?
I can now, yes.
Okay, great. So we'll go on the record now. This is Miller versus Miller, file number 2520020. The record should reflect that both parties are connected here today, Mr. Miller by phone and Miss Miller by Zoom video. This is the date and time set for the court to enter a judgment of divorce in this case. Mr. Miller, is that how you wanted to proceed today?
Yes, sir.
Miss Miller, is that also how you wanted to proceed? Ms. Miller, were you able to hear that? Ms. Miller, can you hear me? Ms. Miller, are you able to hear me?
Yes, I had lost signal and it just came back up.
Okay, I'm gonna have you turn off your video. Can you do that? All right, can you unmute, but leave your video off? There we go. If you turn off your camera, sometimes that'll save some of the bandwidth, so you won't freeze up as much. So if you can just leave your audio on, but just turn off your camera.
I think I have it now.
Okay, all right, we'll try. So did you want to proceed with finalizing the divorce today?
Yeah, go. I just don't want to dispute anything at all.
Okay. All right, so Mr. Miller, can you raise your right hand, please, and let me know when it's raised?
Yes, sir.
And Ms. Miller, can you raise your right hand? Thank you. Do you both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I
Yes.
do.
Thank you. You can both lower your hands. I'm going to ask you both some questions. The questions I'm going to be asking are those that I'm required to ask to establish the grounds for divorce under Michigan law. As the filing party, Mr. Miller, my questions are going to start with you. Mr. Miller, you filed a complaint for divorce in this case and you signed that complaint. Is that true?
Yes.
At the time you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes.
Had you been a resident of Otsego County for at least 10 days?
Yes.
In the complaint for divorce, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you filed that complaint?
Yes, sir.
Does that remain true today?
Yes, it does.
Are there any children who are under the age of 18 that were born to or adopted by you during the marriage?
No.
Under the judgment of divorce, you will not be receiving any spousal support or alimony. You understand that you would be waiving that forever, that you would not be able to come back later and ask the court for that?
Yes, I understand.
And do you agree that you and Ms. Miller do not own any real estate or real property together?
Yes.
And that you have already divided up any debts or assets of the marriage between the two of you, is that correct?
Yes, sir.
All right, thank you. Ms. Miller, have you heard all the questions that I asked Mr. Miller?
I agree with everything, yes.
Is anything that he said untrue to your knowledge?
I'm sorry, what was that?
Is anything that he said untrue?
No, nothing is untrue.
Okay. Are you currently pregnant?
I'm sorry, sir. I have a hearing problem and it just bounces around.
Okay. Are you currently pregnant?
No,
Okay. Under this divorce, you are also not going to be receiving any alimony or spousal support. You understand that you cannot come back later and ask the court for that either.
I understand.
Okay. And do you agree that the two of you have already divided up any assets or debts of the marriage?
There are no assets, so yes, I understand.
Are you asking to have your last name changed?
No,
Okay, thank you. The court finds that the statutory grounds for divorce have been met by the testimony of the parties. I will grant the divorce. I've signed that judgment, so your divorce is final as of today. Mr. Miller, did you have any questions at all?
No, sir.
Ms. Miller, do you have any questions?
no, sir.
Okay, thank you. That's all for today, and you're both free to disconnect at this time.
Okay,
Thank
thank you.
Okay, sir, are you Joel Beanman?
I am.
And Miss Joyce, are you there? Can you hear me?
I am. Yes, I can hear you.
Okay, great. So we'll go on the record. This is Beanman versus Joyce, case number 2520019. Both parties are present today by Zoom video. I have this set as a final hearing to enter a judgment of divorce in this case today. Mr. Beanman, is that how you wanted to proceed?
Yes, Your Honor.
And Miss Joyce, is that how you wanted to proceed as well?
Yes.
Okay, so I'm going to place you both under oath, and then I've got a series of questions that I need to ask each of you. The questions that I'm going to be asking are those that I'm required to ask to establish the grounds for divorce under Michigan law. So can you both raise your right hands? And Miss Joyce, I can't see you, so if you can let me know when your right hand is raised, please.
I apologize for that. I'm not too sure why the video is not working, but yes, it is up.
Okay, thank you. Do you both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can both lower your right hands. Mr. Beanman, as the party filing for divorce, most of my questions are going to start with you today. You filed a complaint for divorce in this case and you signed that. At the time that you signed that, had you been a resident of the state of Michigan for at least 180 days?
Yes, Your Honor.
Had you been a resident of Otsego County for at least 10 days?
Yes, Your Honor.
In that complaint, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you filed that complaint?
Yes, Your Honor.
Does that remain true today?
Yes, Your Honor.
Are there any children who are under the age of 18 that were born to or adopted by you during the marriage?
No, Your Honor.
Under the judgment of divorce, you would not be receiving any alimony or spousal support. You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that.
Yes, Your Honor.
And do you agree that you have divided up all the assets and debts of the marriage between yourself and Ms. Joyce?
Yes, Your Honor.
And there is some real estate or real property that the two of you own together. Is that correct, in Mishaway?
That is property that I purchased while we were married. She is not currently on the title or on the mortgage, but I'm putting it in there for preservation in case if I decide to sell the property, that just makes it much easier for the title search to occur.
Sure. So that's going to be awarded to you, and you're also going to be responsible for any debt associated with that property. Is that correct?
Yes, Your Honor.
Okay. Mr. Beanman, from your standpoint, are there any issues remaining regarding the division of assets or debts that would need to be decided by the court?
No, Your Honor.
Okay, thank you. Ms. Joyce, have you been able to hear all the questions that I asked of Mr. Beanman?
Yes, I have.
Have you been able to hear all of his answers?
Yes.
Do you have any reason to believe that any of the answers he gave were untrue?
No.
Are you currently pregnant?
No.
Under the divorce, you also would not be receiving any alimony or spousal support, and you understand that you also would be waiving that forever and would not be able to come back later and ask the court for that.
Yes, sir. I understand.
And do you agree that you and Mr. Beanman have divided up all the property and assets and debts of the marriage between the two of you?
Yes.
And do you agree that the Mishaway property will go to him?
Yes.
Okay. All right, the court finds that the statutory grounds for divorce have been met by the testimony of both parties. The court will sign that judgment with today's date, so your divorce will be final as of today. Mr. Beanman, did you have any questions at all?
No, Your Honor.
Ms. Joyce, did you have any questions?
No, Your Honor.
Okay, thank you. That's all for today, and you're both free to disconnect at this time.
Thank you.
Okay, looks like we have all council connected, so we'll go on the record. This is the matter of the estate of Ernest Flint versus Gaylord Opco and other parties. This is file number 2519996. If I could have council put your appearances on, starting with plaintiff, please.
Good morning, Your Honor. Donna McKenzie appearing on behalf of the plaintiff.
Morning, Judge Geeps Sebezma on behalf of defendants Gaylord Opco, Everest Opco, Blossom Healthcare, Prestige Administrative Services.
Morning, Your Honor. Daniel Ferris appearing on behalf of CHS Therapy LLC, CHS Opco LLC, Adaptage LLC, CHS New Age LLC, and AP Rehab LLC.
All right, thank you. Ms. McKenzie, can you just kind of give me a quick outline of your view of the facts of the case and what you would like to see for scheduling going forward?
Yeah, absolutely, Judge. This is a nursing home neglect case involving a transfer that resulted in an injury to my client. The transfer was done with a Hoyer lift, and my client got stuck in the lift and suffered an injury that resulted in his decline. Judge, I have had conversations with both defense counsel prior to today. And unfortunately, Mr. Ferris's client is uninsured. And the plan is to try to negotiate a settlement of this matter sooner rather than later to avoid incurring costs. Whether that is successful or not is yet to be seen. But we do have both defendants who are willing to participate in negotiations. So I would think that if we had a little bit of time to negotiate to see if we could work that out, and if not, followed by some time to do some discovery, I think that would be really helpful.
Okay, Mr. Ferris or Mr. Sebezma?
I have no objection to that plan, Your Honor.
No objection from me either, Your Honor. Thank you.
All right, I guess based on what all counsel had to say, my thought would be maybe to just give this just an initial period of allowing you to engage in some informal negotiations, maybe 60 days, maybe even 90 days, and then set it for another scheduling conference. If that's not successful, then enter a scheduling order and enter all the the typical dates that we would do for that. My thought is, it sounds like maybe you're going to try and reach some kind of early resolution, and rather than entering all those dates and going through that, it may be unnecessary. I mean, Ms. McKenzie, do you have any objection to doing that?
No objection. I would just say I think 60 days would be wonderful, Judge. That would be more than enough.
Defense counsel, either do you have an objection to that time frame?
No, Your Honor.
No, Your Honor.
Okay, so I'm just gonna set this for like an initial period of 60 days for some informal negotiations. The court will set it for a formal scheduling conference in 60 days. If the parties are able to reach a resolution prior to that and submit the closing documents, we'll just take that date down. If not, then we'll meet again in 60 days and the court will enter a formal scheduling order in the case and we'll go forward from there. Ms. McKenzie, any other matters I can address for your side here today?
No, thank you so much, Your Honor.
Defense counsel, either of you, anything I can address for you today?
Nothing else for me, Your Honor. Thank you.
Nothing for me, Judge.
Okay, thank you. That's all for today. The court will send out a notice of date and time of that next hearing in 60 days, and all parties are free to disconnect.
Thank you.
Thank you very much.
Thank you, Your Honor.
Okay, sir, is your name Thomas? Is it Aka, or how do you pronounce your name?
Okay, yes. Good morning, Your Honor.
Okay, good morning. Ms. Collins, are you appearing? Oops, sorry. If you can unmute, I was too quick on the mute button there. Are you appearing on behalf of Mr. Aka today?
Yes, that's correct, Your Honor.
Okay, and then we have Mr. Rolla on behalf of the people. So we'll go on the record. This is Shasinski versus Aka, file number 11-14074. All parties are present by Zoom video today. This is Mr. Aka's application to set aside a prior conviction for contempt for violating a personal protection order back in 2011. I had a chance to review the file generally, as well as the application to set aside the verdict prior to the hearing today. And so, Mr. Rolla, I'm going to just start with you. Do the people take any position on whether the court should grant the relief today? So there we go. Your voice wasn't coming through at first there. I thought you were.
Sorry, can the court hear me now?
Yes, thank you.
As I indicated a moment ago, no, the people don't take a position. I'm appearing on behalf of the state as we got notice of this. I did advise your office through your clerk that I would be coming in via Zoom. Thank you.
Okay. Thank you. Ms. Collins, it's my view that from a technical standpoint, Mr. Akat's met all the procedural requirements. So what's left is the court's determination as to whether or not his behavior and circumstances since that time would warrant having it set aside and whether it's in the public interest to do so. I typically have counsel, when we do have counsel, just conduct some questioning of their client as to those 2 points. Are you prepared to do that today?
Yes, Your Honor.
Okay, proceed whenever you're ready. I usually do it unsworn, unless you would prefer that I swear your client in.
Nope, we can do it without swearing him in.
Okay, thank you.
All right, Mr. Akat, so you've heard the standard that the court has to consider for this expungement request. Can you tell the court what was going on in your life back in 2011 when this case happened?
Back in 2011, good morning, Your Honor, and everybody. I was with Peggy up in Gaylord for 3 or 4 years together, and I was an alcoholic, and we had gotten into an argument, and she, based on a friend's suggestion, had brought about a PPO upon me. And in my state, I attempted to reconcile with her, and therefore, unfortunately, violated the PPO against me. And
oh, wait, I can stop you. And so you had mentioned that you were an alcoholic. Is alcohol still a part of your life?
Oh, no, not at all. I am 27 months sober as of today.
And what changed in your life that alcohol is no longer a part of it?
Honestly, I turned 50 and I was getting, sick and tired of being sick and tired of waking up every morning and being sick. And I put myself through alcohol poisoning. Above and beyond that, I had become a grandfather in the previous 4 years. I had just found out that I am a grandfather twice over now, to 2 beautiful children from my son. I started getting back in shape. I became employed with Meyer Superstore in Southfield, Michigan in October of 23. That job is excellent. I love it there. I love dealing with the public. A lot of it has to come from, I attend Lincoln Behavioral Services here in Redford, Michigan, in Dearborn Heights, for the last 5 to 6 years at least. I have a therapist psychiatrist, a counselor. I attend group there. I am very well regarded for my sobriety. My life just, I wanted a better me, and that's why I quit alcohol and tried to become better.
And tell me why you're seeking the expungement. What does it mean to you?
Taking the expungement would possibly allow me from a better legal aspect, trying to get my license back. I have been without a license for 25 years, largely due to my alcoholism, and I just didn't want to play with court.
So this is the first step from in the legal realm as you continue your path forward. Is that
Yes, ma'am.
accurate representation of what you said? Okay.
Yes, ma'am.
And you had mentioned that you attend Lincoln Behavioral Services and you have some support there. Tell me more about the support that you have there. How often do you attend? What type of treatment is it?
I see my therapist one-on-one every week to 2 weeks, depending on what's going on with her schedule and mine. Normally every Thursday. After her, I possibly attend group. I see what's happening with that.
Is that for substance abuse?
Group is kind of like an AA meeting. It's a anger management meeting. It's a lifestyle meeting. It's what's going on in your life kind of meeting. It's everything all balled into one for like an hour and a half.
And do you have any criminal charges pending?
Not at all.
Have you been convicted of more than 3 felonies in your life?
Not at all.
No. Okay.
No, ma'am.
I have no further questions, Your Honor.
Mr. Ockett, obviously having your driver's license would make a lot of things in your life easier, I'm sure.
Yes.
What kind of things do you want to do if you're able to get that back with this being expunged?
Sorry about that.
Yeah. Are there
yes.
activities, are volunteer types things? Is it employment? What aside from just the normal convenient things that having a license would do
to get
for
my
you?
license, to get my license back would be great because I'd be able to drive to see my mother. She's currently going between a home and her trailer with her basically husband, common law. She just turned 80. She has Parkinson's. She's kind of with it some days. It's killing me not to see her. That's one part of getting my license back. Another one would be to progress in work, can become a management position. I don't have to rely on the bus, which I have had to do since the beginning of work. The weather, the winters, some days in the summer, it would give me more freedom to pursue that. I own a truck. There is a 30 by 10 storage unit from when my mother's house was foreclosed on 11 years ago that needs to be emptied. That would come in great help, either that or renting a U-Haul. I am currently in my grandmother's house here in Detroit. It was in the family since 1939. I've been here for 10 years. Well established, and looking to have a quick claim deed done here with my mother for possession of the house. It's all lined up. I just have to get together with her and with a notary public. It would just open up so many possibilities and avenues to my life to just keep getting better.
Okay. All right. Thank you. Having heard Mr. Ockett, Mr. Rowland, do the people take any position on the last 2 factors?
No, Your Honor, thank you.
All right. So I did review the file. I think there's a couple really relevant factors here regarding the underlying charge itself. First of all, the court recognizes this was almost 14 years ago that this occurred. Mr. Alcott, in reviewing the application, does have one drunk driving since then, but certainly no assaultive offenses, nothing in the way of a personal protection order, and no violations or other criminal activity. The court also notes, having reviewed the file, that the personal protection order was actually terminated prior to its expiration date by Judge Murphy, indicating that Judge Murphy found that there was no, at that point, no reason for it to continue through its natural expiration date, which the court finds to be a mitigating factor here. Having heard the statements of Mr. Alcott, it does appear that he's taken steps since this incident to correct his life, to make sure that this type of thing doesn't happen anymore by addressing his underlying alcohol issue, which again, reviewing the file, it's clear that that was a major part of this incident. And then finally, the court finds that it is in the public interest for individuals to have a greater ability to care for elderly relatives, which sounds like is an issue for Mr. Alcott. It's also in the public interest to have individuals seek better and more gainful employment, which having this expunged would also allow Mr. Alcott to do. So the court finds that the remaining two factors have been met. And so the court will grant the application. And Ms. Collins, if you can submit, I did not see in the file a order setting aside. So if you could submit that to the court, I'll sign that once it's presented.
Will do, Your Honor.
Okay, thank you. That's all for today. All parties are free to disconnect from this hearing at this time.
Thank you very much, Honor. Thank you.
Okay, our last one is in person, so we can gingerly slide that out.
Yes, for sure.
Just let me know when everybody's ready.
Okay, and you just want it like right here for right now, and then we'll move it back.
Yeah.
Okay.
Just enough so that it's out of the way.
Okay.